evening. You're watching The Digital Age. I'm Jim Zirin. Philip Howard, our guest tonight, is a prominent lawyer and social reformer. His first book, written in 1998, was called The Death of Common Sense. The Death of Common Sense argued that we are being suffocated by a multitude of complicated rules and regulations which no one really understands. The book won Philip Howard vast critical acclaim, but unfortunately, very little happened in the way of change. In 2002, Philip Howard wrote another book. That book was called The Collapse of the Common Good. And in it, Philip Howard addressed a number of issues that confront us at the present time: education, civil justice, health care. And in all of these issues, he advocated some more social reform. That book also met with great critical acclaim. However, very little happened in the way of change. So now Philip Howard is taken to the web, and he has a website. And the website is called Common Good: Restoring Common Sense to America. And you can take a look on your screen at the homepage. And there, Philip Howard again tries to make his case for social reform. So our question tonight is, can the net prevent the collapse of the common good? And here to discuss it with us is author, social reformer, Philip Howard. Now tell us about your website, Philip. Why did you start it, and what do you hope to accomplish with it?
Well, it didn't seem like the political parties were really addressing problems in the right way. And that's the dominant mode of political and social discourse, is through our parties. And the news media act as stenographers. They kind of repeat what the political leaders say. So we thought that it was important to start a new parallel discussion with thought leaders from around the country addressing honestly what was needed to bring order to schools or contain costs in healthcare or issues like that. And so we've been using the web as an organizing means to bring thought leaders together to begin to advocate for fundamental overhauls.
And do you know at all how many hits you're getting to the site?
Somebody knows it. I don't know it. But I don't think it's not like MoveOn.org. It's our audience is really thought leaders, media, and maybe some political leaders. So that's the target audience at the moment.
But you feel that you have a growing audience on the web.
Well, we have a growing audience on the web, and we have a growing audience among what we think is the most important audience to bring together, which is to bring people who are supposedly leaders, for example, in healthcare, out of their respective silos, wherever they are, think tanks or universities or hospitals, onto a common platform, which is our website, and in forums, and begin to discuss the nature of the reforms needed, which are not tweaks. I mean, we're not going to get there by assuming that the hundreds of thousands of pages of regulation in healthcare, somehow we can build upon those and fix the system. I mean, they're part of the problem.
Do you have a blog on the website?
We don't have a blog. We're actually about to start an online forum, which is not a blog either, but it's going to be but it will the public can participate, but in a side forum, if you will. But we're going to have a forum of thought leaders coming together in moderated discussions throughout the presidential campaign, discussing different issues and what's really needed to fix them.
So if I log onto the site and I see something there I either agree with or disagree with, I can put it up on the site and let you know what I'm thinking.
Absolutely.
Now, you say on the website, that your mission is to restore reliability to our legal system. Right. Is our legal system unreliable?
It certainly is, yes.
Why is it unreliable?
Well, because it's
certainly I go to court and I have a case and I win the case. It's pretty reliable.
Yeah, exactly. That's because you always represent clients that are in the right. But no, what's happened to American law, which is unlike any other legal system in the world, is that in civil justice it's become an ad hoc process. There's no effort at predictability. Juries are generally pretty sensible. So there's nothing wrong with the jury system, but they don't have the capacity to make consistent rulings. One jury could say, oh, a seesaw is fine, it's a reasonable risk, we're not going to allow somebody to sue because the kid fell off the seesaw. And then 3 juries later, the jury may decide the opposite. And that one jury, let's say it's one jury out of 25, the availability of that possibility means that the whole society gets rid of seesaws because they don't want to take the risk. There's no law there. The people need a sense of predictability and reliability. Well, is the seesaw a reasonable risk or not? And our justice system is not giving them that.
So why don't you lobby the legislature to pass a law saying that no one can sue who was injured on a seesaw?
Well, unfortunately, if you did that for every single life event, you truly would have the death of common sense. You would have 10 million new laws, because there are that many circumstances in life. So at some level, you have to leave it to judges running the courts to start drawing boundaries. Somebody brings a claim for $54 million because the cleaners lost a pair of pants, which is a claim brought this year in D.C. The court should say, on the first time it appears in the courtroom, maybe you have a claim in small claims court for your lost pair of pants, but I'm not going to allow you to make a mockery of the system of justice by pursuing this and taking it to a jury. But the judge didn't do that.
Well, yes. One of your critics, not all of them have been entirely favorable, one of them said that you have a great affection for horror stories. Now, the $54 million pair of pants is certainly a horror story. What did the judge do with that case? Did he allow it to go forward?
Yes, it went to a jury.
Went to a jury.
It went to trial, full trial, 2.5 years. And of course, the right result happened. Nobody's ever going to lose that case. Right. But people have to suffer through 2.5 years of sleepless nights. Well, there's a 1% chance I might lose, or whatever. And you talk to any doctor, that's how they feel. I mean, it's one of the reasons healthcare is suffering a nervous breakdown.
Well, doctors have another set of rules because doctors have a shorter statute of limitations than other professionals. There are screening panels in many states that screen out these cases. There's no prejudgment interest in a medical malpractice case. There are many things that protect doctors, and probably 1/3, I think the last statistic I saw, the last metric, was 1/3 of the medical malpractice cases that were brought ended in a settlement, either by verdict or by agreement, of less than $1 million.
Yeah.
So it isn't such a parade of horribles.
Yeah, it is actually. I mean, the medical system, which is medical justice, is the most studied probably area of civil justice. We're in a joint venture with the Harvard School of Public Health to look at this, and juries generally get it right. The cases generally get resolved, according to the latest study, with only about a 25% error rate. Now, but if you're a doctor, one bullet in 4 chambers is not such a good game. If you may be held liable, and if you're an obstetrician, the justice system is notorious for awarding huge damages, for example, to babies born with cerebral palsy, when almost nothing the doctor did could have caused that. It's basically a virus in the womb.
Well, but not always. I mean, there could be a botched forceps delivery. There are many ways. There has to, in every case where there's a verdict against the doctor, there has to be an expert witness who's a doctor who says that what the doctor did varied from standard medical practice. Now, you may think that's a hired gun. And you may,
I do, yeah, that's right. That's right.
And they put up witnesses who'll say anything if they're paid, but there's also a gateway hearing. There are lots of things that are done to protect doctors within the legal system.
We could argue all day about whether the system is fair. Well, we don't think it is fair even to people who are injured. They can't even get a lawyer unless they've been injured for hundreds of thousands of dollars, because it takes 5 years on average to get to settlement. So the system doesn't work for anybody. But the goal here is not just to have a system of justice that's fair. The goal is to have a system of justice that's trusted, that provides a platform for choices for how to improve patient safety, for how to do cost containment. And without any question, the Institute of Medicine, all of these groups, who are the most respected groups in healthcare, have come out in favor of abandoning the system of justice and creating something that's reliable. I mean, our coalition now includes the largest consumer group in the country, AARP, every patient safety expert in the country. These are not tort reformers. These are people whose only interest is improving the quality of health care. So,
but you advocate starting health courts.
Yeah, that's right.
In place of the common law courts that we now have throughout the country. What are health courts going to do for you?
Well, health courts will provide a level of consistency, and they'll gather data so you can feed it back into the system about mistakes that are made. And they'll pay people who are injured 5 times more quickly than the current system. It'll be much cheaper. And you'll have consistency. They'll have neutral experts, not the hired guns, neutral experts who will come and advise the court about standards of care. There'll be written opinions, not just a jury verdict that goes thumbs up or thumbs down, and the next one can be completely inconsistent. You'll have written opinions, so there has to be at least an aspiration towards consistency and predictability. And again, that's why the progressive left, not just the right, the left is behind this. The only people opposing it are the lawyers and the what I'll call the ideological left, Ralph Nader, people like that.
Well,
maybe you, Jim, are you opposed to it?
Well, no, I mean, I guess I was brought up in the adversary system, so were you, and that is the crown jewel of our legal system, which we inherited from the English common law. And the idea is that if there's someone on each side arguing their side of the case, you'll have a better chance of arriving at the truth.
We still have that.
Than you have in France or Germany or somewhere where the judge conducts the inquiry in abject neutrality.
Well, this case would have lawyers for the plaintiff and lawyers for the defendant too. It would just be, it would turn down the heat a lot. It would be much more on the merits. Hospitals have to open their kimono and expose all their files. If not, there are penalties. And it's just
now.
There are systems like it, administrative compensation systems, not exactly like it, in Scandinavia and in New Zealand. They work very well. And all we're calling for is pilot projects. We're not trying to flip a switch. But we've got a whole bunch of big hospitals that have publicly volunteered to be the pilot, like New York Presbyterian Hospital, for example, and Johns Hopkins. And you can never make the choices needed to fix health care until you have a system of justice that's reliable to uphold those choices.
Well, isn't reliability afforded by rules such as the Federal Rule of Civil Procedure, Rule 11, which says that a lawyer can't bring a suit for an improper purpose? It has to be based on existing law. It has to be evidentiary support for the allegation. The lawyer has to sign that.
No,
and
that's
if he's
just
signing
process.
it falsely, well, if he's signing it falsely, these lawyers you don't like will be disbarred.
Yeah, but it's not a question of, this is not a question of frivolous lawsuits versus non-frivolous lawsuits or abusive lawsuits. Rule 11, first of all, Rule 11, as you know, is never used, so nobody ever enforces it. This is a question of making value judgments about what standards of reasonable care are. Reasonable people can differ over what those judgments are, but our point is somebody has to make the judgment so the doctors know where they stand. And so when you have a jury deciding, jury by jury, inconsistently, in similar fact situations, what that leads to is a pervasive distrust, indeed, paranoia, within medical professionals that is completely counterproductive. I mean, it infects the smallest aspects of their practice. I mean, I was talking to a friend who's a pediatrician in Charlotte, North Carolina. That's not an area that gets a lot of lawsuits. He's a very distinguished doctor in his community, very distinguished person, somebody I've known a long time. He said, I've completely changed the way I practice. So now, if a healthy child comes in, I write 30 lines on the patient chart of everything I observed instead of just saying the child looks normal. That's counterproductive. If something really goes wrong, somebody's going to have to read through those 30 lines. They're going to see nothing. But they're going to have to read through them to get there. It's not productive to write too much. And yet he's, in a sense, in that small way, practicing a kind of defensive medicine that's not.
So he's covering himself.
He's covering himself. And doctors spend all day covering themselves.
Well, but is there anything inherently wrong with encouraging doctors to keep a record that so that when someone looks at it years later, they can understand why the doctor did what he did?
Yes, if the record doesn't say anything. If those 30 lines can all be boiled down to everything looked normal, Yes, it's counterproductive.
Well, yeah.
You can make somebody read 30 lines.
Well, sometimes there's a little more to it than the 30 lines and everything looked normal.
Well, he was giving me a case where there wasn't more to it.
Yeah.
If there's something that's worth noting, he'll note it.
Yeah.
It's important in life to focus on things that are important. If you assume that you have to, it's like thinking about how you ride a bicycle. You can't do that. You just ride the bicycle. So you have to, at some point in making life choices, focus on the things like where you want to go or what you're doing.
Let's move on to education reform, which is another one of your planks. What are you trying to accomplish there?
Restore the authority of teachers and principals to run the schools. I mean, we don't, the decline of the culture of public schools is the most underrated problem, I think, in the American school system. It's a recent survey found half the teachers said they spend at least half their time maintaining order. Well, that's an important problem. That's half the time they're not teaching. One kid disrupting a classroom means 29 kids can't learn because they're all focusing on that. So we have a joint venture now that we've worked out between Randy Weingarten, the head of the New York City Teachers Union, and Joel Klein, to design a new system for discipline for New York City schools. And we're going to start piloting it in 2 schools in New York this year. And
what are you going to have? You're not going to have corporal punishment.
Absolutely. We're going to just beat them. No, we're going to focus on culture. So we're going to go in and first work with the teachers and the principals on the importance of culture, have a curriculum that's related to the importance that the students not be disruptive, respect other people's right to talk, how it affects other people if they are disruptive, etc. And then introduce that starting next year in the schools. And then if the kids don't abide by that, if they start disrupting it, have really quick, immediate reaction that they're out of the classroom, and we're finding resources for them to go to. But we're not going to allow a kid who refuses to play by the rules to disrupt the learning of everybody else. We're going to have separate classrooms and separate resources, and work with, and there are a lot of troubled kids, and they need a lot of resources.
Well, what is the present situation? In many schools, you have guards who are right there on the premises.
It's a complete free-for-all. Anything short of physical violence, kids get away with. They tell teachers to, they're
where to go.
Where to go.
And the teacher can't send them to the principal.
No, principal just sends them right back. I mean, it's not absolutely not. It's a.
And that says the system contemplates that if the teacher sends a kid to the principal sends the kid back.
Well, there's no place for them to go, and if you try to suspend them, you can't send them home. And if you want to send them home, you've got to go through, quote, due process proceedings, which have mutated into a sort of a version of a criminal trial, as if you were sending the kid to jail instead of sending him home. And the truth is, in the worst schools, these kids don't have much to go home to. So you do need to provide resources for the kids who are troubled, but the cost that's too great is letting them destroy the learning of everybody else, because most kids want to learn. And so we have to create a system that focuses on the job of schools in doing that. If you go into any school that's successful, I mean, education experts will say that you can tell in 5 minutes whether it's a good school or not. Why is that? Because you feel the culture. You feel people, how people react to each other and respond to each other. It's not sort of chaos. And so we're trying to build that in these 2 pilot projects. Charter schools do it, or good charter schools, but nobody's actually ever tried to do it in an organized way in an existing, 1,000-person school.
When will the new program be implemented?
Well, it's going to be implemented, school-wide starting next year in September of 08. But we're starting to work in the schools to build the resources, if you will, of the teachers and the principal to deal with it this year.
Let's move on to another issue, which I know interests you, which is the value of play.
Oh, yeah.
You seem to focus on swings and in playgrounds and jungle gyms and seesaws. And we know that in many communities there are no seesaws anymore in the parks because too many kids have been hurt and the city doesn't want to be sued.
Right.
And
or in the alternative, no kids have been hurt, but they're scared they're going to be sued.
Well, if it's a safety hazard, they should be scared. there's a balancing that has to be done between safety and making it. Yes, there's two for the seesaw. So,
right.
But isn't it legitimate for municipalities to say we don't want to be bothered with the expense of providing safe conditions for a seesaw? I mean, we're going to have other things that don't present the same hazard, and what is the real virtue in a kid using a seesaw not the way it was supposed to be used, but walking on it and then it falls down and he falls off and he cracks his skull open.
Yeah, you did that, right?
I did that.
Yeah, I did it too. You learned to take risks.
People say that maybe it had its impact, but we all did that. But the question is, and our parents didn't sue the city or the playground department. But why do you think that, or what could be done to change this mindset?
Okay. Well, first, the problem, it is incredibly important for kids to take risks. Not crazy risks, but risks. They need to learn their own capacities. They need to learn that if you go too far, you might fall and hurt yourself. And again, you don't want to...
they may want to become hedge fund operators.
Yeah, exactly. But I mean, there was this... wonderful English woman who was active in trying to restore children's play in English. It's better a broken leg than a broken spirit.
Right.
And so things like jungle gyms, which have also disappeared, for example, are really useful in part because the risk is fun. I mean, kids won't do something if it's not a little risky. That's part. I mean, older kids, that's part of the fun of it. And so you take it out, you just end up having kids doing stupid things like climbing to the top of a small swing set and jumping off rather than doing the jungle gym, because there's no fun in these sort of gerbil-like, these like inflated, multicolored gerbil-like plastic constructions that are great for 2-year-olds but not for 6-year-olds or 7-year-olds. So there's a broad group of people, and again, we're bringing these people together on the web. There's a broad group of people who are in their silo, in this case, pediatricians and adolescent psychologists and others, who say it is vital for a sense of purpose in kids and for a sense of self-awareness to allow kids to take reasonable risks.
You talk about warnings on products. You talk about the McDonald's coffee case.
Remove baby before folding stroller. That's useful. That's a really useful warning.
There's a parade of horribles that you refer to, but most of these cases don't go very far. I mean, even the McDonald's coffee case was ultimately settled. The judge reduced the punitive damages.
Sure.
I mean, do you feel that the legal system has really broken down and that Americans are obsessed with not with safety and obsessed with legal fear that they're going to be questioned in court for anything they do?
Well, first of all, you're absolutely right that the extent of the risk in the legal system is radically overblown. It's like a shark attack. The odds of being bitten by a shark are virtually nil, and yet, people kind of think about it whenever they dive through a wave. So, the legal system has taken that on. And so there's an aspect of this which is what the Nobel Prize winner Daniel Kahneman would refer to as the overweighting of low probabilities. There's a kind of a risk aversion that's taken over.
And there is a doctrine of assumption of risk.
Yes, but it's not too healthy at the moment.
Well, it's alive and well. They read it to the jury, and the jury can apply it if they want.
I think that the problem with the legal system, as I said at the beginning, it's not so much that most cases end up with stupid results, is that the system tolerates outliers. And it tolerates people bringing claims that act as extortion, like, the $10 million for the broken leg sort of claim. Well, chances are you're not going to ever be liable for $10 million, but you've got to go to sleep if you're the doctor or whatever. You're sleeping with that for the years that the case goes on.
Well, then what about insurance? Most of these cases are covered by insurance. You had one case, one of your horror stories was the woman who broke her ankle when slipping on the steps in front of her in-laws' house, and she sued her own in-laws. But of course, they were covered by insurance. She was really suing the insurance company.
Yeah, but that isn't good for society either. I mean, that just, in a second level effect of that, it just raises everybody's insurance rates. I mean, the fact that some
Well, jurors understand that.
I mean, some person, yes, but as you know, 2% of cases or something like that go to the jury. Most people don't want to spend the money, take the risk, et cetera, of going to the jury. It's another problem with our legal system.
Holmes said, in every one of these cases, we all agree there's been a loss or an injury.
Right.
Someone's been hurt. And the question is, who should bear the loss? Right. Should it be the person who has been injured, or should it be someone else who may have caused the loss by being negligent, or if they haven't been negligent, then the plaintiff should bear the loss.
And the difference,
that's the nature of the inquiry.
And the difference in our point of view is we think those lines have to be drawn as a matter of law. Well, what's a reasonable risk? Whether it's okay for a doctor to give aspirin for a headache rather than ordering an MRI has to be decided as a matter of law. Whether a seesaw is a reasonable risk, not whether it's broken or not, it's a factual question. Whether a seesaw is a reasonable risk or a jungle gym is a reasonable risk and should be decided as a matter of law. People need to know where they stand. That's what law, the whole point of law is to draw these boundaries, and it doesn't do that anymore.
Well, I have a couple of quick questions for you because we're running out of time, but one is, do you favor a system such as the British system where the loser pays the legal fees of the prevailing party?
No, I don't, because it favors the deep pocket. I think real people need to have access to the courts without thinking that they're going to have to, pay General Electric's, lawyers' bills. So I do favor a system where a judge decides at the end of the case whether there was ever a reasonable basis for the claim. Somebody makes up a claim, extortionate claim, it turns out to be fraud, they ought to pay the other side's legal fees in that case. But that's a...
Well, that can be done. There are provisions for sanctions.
Yeah, that's right.
The second question is, do you favor jury trials in civil cases?
Yes, for disputed issues of fact. But not for standards of care.
As guaranteed by the Constitution. So I have a question for you. And the question is, can the net prevent the collapse of the common good?
Absolutely. It's a great organizing mechanism. We're going to have this website that comes up in February of next year that's going to parallel the presidential campaign. And it's going to be a discussion that you'll find nowhere else of thought leaders from left and right, people like Newt Gingrich and Bill Bradley, and as well as academics and experts in different fields, talking about the end-of-life care, different issues. And that honesty by people who have no axe to grind but just a legitimate point of view, the net can provide us, and you can't get it anywhere else.
Well, here's to honesty. Philip Howard, thank you for coming by.
Jim.
And thank you for coming by. Tune in next week for more on the digital age. For the digital age, I am Jim Zirin. Thank you, good night, and all the best.